Thomas A. Lenz is a partner in Atkinson, Andelson, Loya, Ruud, and Romo, AALRR, a leading full-service firm with over 180 attorneys in 9 offices in California. Mr. Lenz handles all aspects of labor and employment law issues and heads the firm's traditional labor and National Labor Relations Board practices. He works with employers in all major industries across California and the West. Mr. Lenz served as chair of the Labor and Employment section for the California Lawyers Association, formerly the State Bar of California, during the 2017-2018 term. He serves as a lecturer in law, teaching at the USC Gould School of Law. Visit aalrr.com for further information on the firm.
Hello, everyone. I am Tom Lenz. I am a partner in the Atkinson Andelson law firm based in Pasadena, California. I will be talking to you today about managing sexual harassment investigations and employee training obligations. This webinar is presented for the Center for Continuing Education, and it's my pleasure to be back working with CCE. It's always an enjoyable experience putting these webinars together for you. We are going to start off talking about the Me2 movement, which no doubt most, if not all of you participating in this webinar have seen in the news, on TV, heard about in the radio, read about in the newspapers. It is all around us, and it has to do with sexual harassment and how people are communicating about it. And really, it's triggering a lot of responses, and employers as well as employees want to know what they need to do. Sexual harassment has been a huge area of litigation over the last few years, and there have been many high-profile cases. We've seen that sexual harassment accusations have impacted many people who have raised the allegations, the accusations. People who are accused have been certainly pointed out in the media, Harvey Weinstein among them being perhaps the most high-profile situation. We've seen that the Me Too movement and the very public expression of concern about sexual harassment there has led to a public discussion. There is increased awareness. There are more complaints of harassment than we've seen in years past. What we have seen in recent years reminds of the experience with Clarence Thomas and Anita Hill several decades ago, during the time that Clarence Thomas was seeking confirmation to the United States Supreme Court. And here we are today, and we are seeing that the discussion about harassment, the Me Too movement, is leading to the introduction of new bills and legislation. I'm going to be talking about a number of things from a California perspective, but it's important to be mindful that sexual harassment is a national issue. It is an issue that is regulated by federal law, and it's important to remember that even if you are not within California and covered by the scope of specific rules that I may mention in terms of bills, legislation, training obligations, it's important for employers, employees, attorneys working with them to recognize that there are laws to comply with in this area. There is a need to look at effective steps to educate yourself, to educate those around you, and to take a preventative step in dealing with sexual harassment, other forms of harassment, and indeed workplace discrimination. So in that regard, I will point out a number of the things California is doing as potentially best practices, because as we've seen over the years, California has often taken a rather progressive approach to new ways to address existing problems. In that regard, California's SB 1343, authored by legislator Mitchell, now makes it mandatory for employers with 5 or more employees and for non-supervisors to receive training on harassment avoidance and avoidance of what California calls abusive conduct, which might be known in other contexts as bullying. California's Department of Fair Employment and Housing is required by this legislation to develop online training courses regarding sexual harassment prevention. Now, it's important to note that even though there may be online training courses, the requirement that California has, and which is a good practice anywhere, is to make sure that the training is interactive. It's 2 hours every 2 years for supervisors in California, and it's 1 hour for non-supervisors every 2 years. But we'll talk more about that as we get into this presentation. SB 1300, authored by legislator Jackson, employers may provide bystander intervention training. This is something where third parties, perhaps not those immediately involved in a situation of harassment, may have a legitimate role to play in terms of stopping an action that could constitute unlawful harassment. Moving to the next slide, discrimination and harassment laws. Let's talk about who is covered. In California, we have a law that is separate and apart from the federal law. Federal law relies upon Title VII of the Civil Rights Act of 1964 and related legislation to address discrimination and harassment in the workplace. In California, we have the Fair Employment and Housing Act, also known as FEHA, which has some broader protections, and we want to emphasize those broader protections here. FEHA is the primary law that provides employees with protection from discrimination, retaliation, and harassment in employment. And the employment provisions of FEHA apply to all employers with 5 or more full-time or part-time employees. So this is a broad scope. Even small employers are going to be covered, and employers with even 1 employee or simply an independent contractor can still find that they can be liable for harassment. So California's law has broad impact and in many ways is a model for what we see elsewhere. Let's talk about what harassment is, because the term is thrown around a lot, but there is a legal definition, and it's important to know that in the context of today's subject matter. Sexual harassment in the workplace is regarded as a form of sex discrimination, which violates Title VII of the Federal Civil Rights Act of 1964, as well as California's Fair Employment and Housing Act. So harassment itself is a form of discrimination, and it refers to both unwelcome sexual advances or other visual, verbal, or physical conduct of a sexual nature, as well as actions that create an intimidating, hostile, or offensive work environment based upon an employee's sex. We're going to talk about what types of harassment there are, because harassment is typically broken down into a couple of categories. But it's important that you know that it is unwelcome, and it could be words, it could be actions, it could be the way someone looks at you or the way someone touches you that is unwelcome. And it's very important to look at how the person who perceives the harassment, the victim of the harassment, considers the conduct to be. Under California law, the offensive conduct need not be motivated by sexual desire, but instead may be based upon an employee's actual or perceived sex or gender identity, actual or perceived sexual orientation, and or pregnancy, childbirth, or related medical condition. So these are a lot of different criteria. It's not just asking somebody for a date. It could be the way in which you talk to them, the way in which you look at them, the way in which you consider them to be sexually. If you do not acknowledge someone's gender expression, the way that that person expresses themselves, the way they see themselves in terms of gender identity. These are issues under California law which can lead to harassment. Let's talk about some examples of sexual harassment. Visual conduct, leering, making sexual gestures, displaying of sexually suggestive objects or pictures, cartoons or posters. I've seen it many times in workplaces where someone will hang a tool calendar with a picture of a scantily clad person, and they'll say, "That's my calendar," but someone else may say, "I am offended by that picture," or the whatever the imagery is on that display. So it could be visual conduct, it could be verbal conduct, making or using derogatory comments, epithets, slurs, and jokes. Many times people will say, "Oh, I was just joking. I didn't mean any harm." But this is an area where the words you use can have consequences beyond anything you ever intended. Verbal abuse of a sexual nature, graphic verbal commentaries about an individual's body, sexually degrading words used to describe an individual. Verbal conduct of these sorts can lead to accusations of sexual harassment. Physical conduct is perhaps more obvious: touching, assault, impeding or blocking movement. These sorts of things tend to escalate a situation and the likelihood that sexual harassment will be found. Some of the more typical categories of sexual harassment are often in the realm of quid pro quo, Latin for one thing in exchange for another, such as offering employment benefits in exchange for sexual favors, offering some sort of uh, uh, wage increase, let's say, or a promotion in exchange for some sort of sexual act, or denying that in the event that sexual behavior is not engaged in. So, offering benefits, making threatening or retaliatory action occur after a negative response, these are quid pro quo harassment. Uh, that's not the most typical type of harassment. Uh, in truth, the type of harassment which occurs more often is what we refer to as hostile work environment. And that is often depending upon the details, where the visual, the verbal, the physical all combine into a perhaps a series of exchanges, a series of details, um, causing a workplace or interaction in it to be unwelcome and uncomfortable for the accuser. The harasser's intent is irrelevant, and sexual harassment may be unlawful, even if it is not motivated by sexual desire. It could be simply that there are words or actions that are linked in some way to a sexual message. Gender is also irrelevant. We see increasingly in the workplace that sexual harassment is not simply an issue between men and women. Men can harass women, um, theoretically speaking, not legally. Men can harass women, women can harass men can harass men, and women can harass women. It occurs in a variety of different situations, and all of them are illegal. So I want to talk about um, the the need to do training. And I think even if you are in a place where California law does not apply, training is very important. Training is part of getting the message out to the individuals in any workplace that harassment is not going to be tolerated. It is something that is going to be addressed in an appropriate, standardized way that is going to maintain a harassment-free environment. And there will be repercussions for those who engage in inappropriate behavior. So California actually requires that employers have a well-drafted anti-harassment policy. I think that's something that any employer anywhere should have, something that spells out the commitment to prevent harassment. And the training really should be based upon the principles of that policy. And so let's look at uh, let's look at what all that would involve. Sexual harassment prevention training should convey and support the policy. Policy should be consistent with law and should prohibit all forms of unlawful harassment. So to that end, sexual harassment is itself unlawful and required to be addressed in policy. Consider whether you should include as well other forms of harassment, which could lead to claims of unlawful activity in the workplace. As noted, harassment is a form of discrimination. And in addition to creating and maintaining an anti-harassment policy, employers should look at some additional steps. Making a policy available to current employees and new hires. Making the policy accessible through an employee handbook or as a standalone policy. Not every employer has a full-fledged employee handbook, but you should at minimum have that harassment policy. It's important to have employees sign an acknowledgement of receipt and understanding, not necessarily an agreement, but a statement that the employee is aware of that policy, knows that that is the rule of the workplace. And it's important that an employer remind employees and supervisors of that anti-harassment policy from time to time. And perhaps provide that policy on a bulletin board or on an intranet so that it is available for employees to see if ever a question arises. Regarding the training obligations, the harassment policy should include a complaint procedure in the event an employee is faced with an issue of harassment. The complaint procedure should be in writing. And the the policy and the complaint procedure should be prepared to deal with all current protected categories under the law. And it should indicate that the law prohibits coworkers and third parties, as well as supervisors and managers who the employee comes into contact with from engaging in unlawful conduct. So it's not just about one employee to another, a supervisor to an employee, or supervisor to supervisor. It could be customers, it could be vendors, it could be any interaction among people where the employer could be responsible for this sort of activity. If the employer knew or should have known, the employer is typically on the hook. So the complaint process should also ensure some degree of confidentiality and a timely response. It's not an issue that's going to be simply set aside and dealt with when convenient. It is important that a harassment accusation per the policy be handled promptly and handled impartially with timely investigations by qualified people. So the accused supervisor is not going to be the investigator. It's going to be something that is done at arm's length so that there is assurance of impartiality and not a predestined result. Documentation and tracking is important, and there should be appropriate options for remedial action and resolution. There should be ways to try to get the matter resolved in a way that works for everybody involved in a timely fashion. Moving on to the next slide. There should be a complaint mechanism that does not require an employee to complain directly to his or her immediate supervisor. There should be an alternative if an employee is more comfortable going to, say, a human resources manager or the controller or whoever is designated by the policy. It certainly should not be the alleged harasser who the employee is required to report to. There should be options. And the policy could include that direct communication is with a number of different people. There could be a complaint hotline. There could be access to an ombuds person. And in California, it's required that you tell employees if you are not satisfied with the mechanism you have internally to deal with harassment, you have the opportunity and the right to go to the Department of Fair Employment and Housing or the United States Equal Employment Opportunity Commission because they are government agencies that exist to address these sorts of issues. A good policy and the training following up on that policy should tell supervisors they should report complaints of misconduct to a designated company representative. It's not an issue you can sit on. It's something you need to inform the appropriate people, such as the Human Resources Department, so that the company can promptly and appropriately resolve the claim internally. Now, it's been the law in California for quite a long time that employers with 50 or more employees must provide training 2 hours every 2 years for supervisors. And the training obligation is being expanded under the legislation I mentioned earlier in this session. So, as of the year 2020, all employers with 5 or more employees must train the supervisors at least 2 hours on the subject matter, and non-supervisors at least 1 hour. So, moving to the next slide, it's important that an employer commit in policy and training that when an employer receives allegations of misconduct, it will conduct a fair, timely, and thorough investigation that enables all parties to participate and provides due process with reasonable conclusions based upon the evidence collected. It's important to have the investigator talk to the witnesses who either know or are likely to know information related to the allegation of harassment. And it should be noted that confidentiality will be kept by the employer to the extent possible, but not that the investigation will be kept completely confidential. It's not possible to keep it completely confidential. There may be a need to know between individuals in management, for example, and that is where there is perhaps some sharing of information in order to achieve the appropriate result. And the policy and training should indicate that at the end of the investigation, misconduct, if it is found, it will lead to appropriate remedial measures. That's not to guarantee anyone that someone else will be fired, that there will be certain levels of discipline imposed or anything like that. It is a more general statement that appropriate measures will be taken. The policy and training should also make clear that employees will not face retaliation because they made a complaint or they participated in an investigation. And what's really key there is that if there was retaliation, it would discourage people from reporting the harassment. And any employer should want to encourage people to speak out, because doing so is going to encourage people to resolve the matter and to get these issues resolved rather than covered up. In California, there is a form, Department of Fair Employment and Housing 185, and it is entitled Sexual Harassment is Forbidden by Law. There may be analogous publications in other areas outside California. This DFEH 185 is required to be disseminated to all employees. So regarding who must be trained, on the next slide, by January 1, 2020, an employer with 5 or more employees must provide at least 2 hours of classroom or other interactive training and education regarding sexual harassment to all supervisory employees, and at least 1 hour to non-supervisory employees. And the training must be done within 6 months of an employee's assumption of the position. So an employer who has provided this training after January 1, 2019 is in compliance by the 2020 deadline. After January 1, 2020, any employer covered by the law must provide harassment training every 2 years. So again, it's 2 hours for supervisors, 1 hour for non-supervisors. And there are special rules for seasonal and temporary employees in California, and also for migrant and seasonal agricultural workers. So if you are dealing with those workplaces with seasonal and temporary or agricultural, you'll want to look into those special requirements. The format of the training is something that should be in a classroom setting through interactive e-learning, through a live webinar, or in some instances in a class, a face-to-face classroom setting. The e-learning training should provide questions on how to contact a trainer who can answer questions within 2 business days. The importance of that interactivity is significant, and the ability to get questions answered will make that training more meaningful. So training may be completed by employees individually or as part of a group, and it can be broken up into segments as long as the total hourly requirement, 2 hours for supervisors, 1 hour for non-supervisors, is met. So let's talk about what the training must cover, and there are a number of subjects that we will want to address. The definition of sexual harassment, for example. And that's under the Fair Employment and Housing Act in California, as well as Title VII of the Civil Rights Act of 1964. Some of the laws and case law which prohibit and prevent sexual harassment. The types of conduct that can be sexual harassment, such as the quid pro quo or hostile work environment categories that I mentioned earlier. The remedies that are available for victims of sexual harassment, and for example, the various components of compensatory or punitive damages, and who may be held liable, strategies to prevent sexual harassment, the supervisor's obligation to report sexual harassment, practical examples of harassment, and the limited confidentiality of the complaint process. We say limited because, again, management may need to share that information. Not to mention, there may be a need or desire among employees to discuss harassment. There have been situations litigated where employers have tried to insist that employees in a harassment investigation not talk about the subject matter among each other. And in fact, the National Labor Relations Board, among other agencies, has spoken on that issue, saying that employees have the right to discuss wages, hours, and working conditions, which include harassment. And to restrict that is to chill their rights under federal law. So if you are looking at an issue of trying to maintain confidentiality among rank and file employees, be very careful with that. Get some research and legal advice before you do so. Format and training topics covered. Again, resources for victims of sexual harassment, including to whom they should report it, how employers must correct harassing behavior, what to do if a supervisor is personally accused of harassment, and the elements of an effective anti-harassment policy and how to use it. California has defined abusive conduct, which is another term for bullying under California's government code. And while abusive conduct is not itself a violation of the law, it is acknowledged to be something which can lead to violations of the law, such as harassment. So California has also taken a progressive step forward to require that harassment training discuss gender identity, gender expression, and sexual orientation, and that discrimination and harassment related to those topics is illegal and needs to be prevented. There should be practical examples which are inclusive of harassment based upon gender identity, gender expression, and sexual orientation. And any training should include questions to assess learning, skill building activities, so that there is understanding and the ability to apply the rules that are discussed. Hypothetical questions, typical of most anything involving law and rules. You understand the issues better with the use of hypotheticals. We'll talk about abusive conduct as discussed by California law on the next slide. And Abusive conduct in California means conduct of an employer or employee in the workplace with malice, so intentionally. A bad faith, intentional sort of conduct that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. And abusive conduct may include repeated infliction of verbal abuse. So comments, derogatory remarks, insults, epithets, uh, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. So it's something that really is not needed, not warranted in the workplace. It could actually undermine, sabotage someone's work performance. And it typically is something that's going to need to be sustained over a period of time. A single act shall not constitute abusive conduct unless especially severe and egregious. One time, typically not enough. But if it's something severe, something that is truly impactful, damaging to someone's performance or the workplace generally, that could be abusive conduct. And it could lead to other types of harassment and discrimination issues, which are themselves illegal. So, under California's rules and best practices generally, who can provide sexual harassment prevention training? There are three types of qualified trainers: attorneys who have been members of the bar of any state for at least 2 years and who practice employment law under the Fair Employment and Housing Act or Title VII of the Federal Civil Rights Act of 1964, human resource professionals or harassment prevention consultants with at least 2 years of practical experience, law school, college, or university instructors with a postgraduate degree, or California teaching credential, and hours of instruction in their experience about employment law under the Fair Employment and Housing Act or Title VII. Let's talk about reporting procedures, which need to be discussed in the training. Training should clearly illustrate and explain the employer's policy and protocol to report harassment. It should be outlined in the harassment policy. And aspects of the reporting procedure that should be included are the need to report complaints immediately. This is not something that can wait. It needs to be addressed right away. Various avenues designated by the policy to report harassment. A request that senior employees provide feedback about whether the reporting policy is effective. In other words, it's staying on top of how things are working to make it better all the time. The need to document complaints and any employer response. The requirement that supervisors and managers review and remain familiar with protocols for complaint investigation and resolution. Also, the requirement that supervisors and managers never guarantee confidentiality of reports or investigations about reports. Also, there should be a statement that good faith reports of sexual harassment will not result in any retaliation. Again, anti-retaliation is critical to the success of a harassment prevention policy and the use of anti-harassment machinery in the workplace. It's important to explain the responsibilities of all employees. Training should make all employees aware of their obligation to follow reporting procedures to resolve harassment, to cooperate in investigations, and also to refrain from harassment and retaliation. There are some other topics that supervisors and managers should cover in training. The definition of a supervisor. An individual qualifies as a supervisor under federal harassment law for purposes of holding an employer strictly liable for the supervisor's behavior, if that individual is empowered by the employer to take tangible employment actions against the victim. Many training topics for supervisors and managers will be the same as those for junior employees, but topics regarding supervisory status and liability are suitable additions to train more senior individuals and to make sure that people know their role. There's a few other laws and bills that are important to go over. I'm just going to touch upon them briefly. Again, these are California specific, but may well touch upon issues that that come up in other areas outside of California, and as a general matter, one should be aware of in considering where the law is going. AB 1619, extension of sexual assault statute of limitations from 2 to 10 years. AB 2770, privileged communications regarding sexual harassment. The scope of what is privileged may well change. SB 224, personal rights, and it has to do with the scope of potential harassment as well as civil liability and enforcement. And SB 826 regarding corporate boards of publicly held corporations. California is now requiring that there be female representation on the boards of publicly held corporations. On the next slide, SB 1300, it clarifies the severe or pervasive legal standard for sexual harassment claims, and it affects releases of claims and non-disparagement language that often appears in settlements involving harassment issues. And it prohibits all forms of third-party harassment based upon FEHA, Fair Employment and Housing Act categories, not just sexual harassment. California no longer allows secret settlements, confidential settlements in sexual harassment and gender discrimination as a result of SB 820. And there are a series of criteria laid out. So what might have been a confidential, sweep it under the rug type of settlement may now be something where people are free to talk about it. SB 3109, right to testify, a provision in a contract or settlement that purports to waive a party's right to testify is void. So big changes in California, which may be seen elsewhere as well. With regard to record keeping as an element of training, it's important that employers track compliance by individual, training year, and it's important to keep records of the training for at least 2 years to show that the employer has complied with the requirements of California law or whatever the law may be in other jurisdictions. Sexual harassment investigation basics are something which we're going to cover next. And investigation is really important because it's part of really the implementation and successful action pursuant to a well-drafted harassment prevention policy. Let's say you have an accusation of harassment in your workplace and you're wondering what to do. As an employer, you need to choose an investigator. And you don't want to choose just anybody. It should be someone who is trained and experienced and who you know will be neutral and impartial. You do not want someone who has a stake in the outcome. You do not want someone who has a preference. You want someone who is going to look at the facts and in a balanced way find out what happened and whether something inappropriate did occur. Not somebody in the chain of command, not somebody involved in the allegations, and then follow a series of steps. On the next slide, step 1, conduct a thorough interview with the complaining party, preferably in person. It's usually best to sit down face to face and to get details about what occurred and to take good notes. Give the accused party, step 2, the opportunity to tell his or her side of the story, also preferably in person. You want to provide a fairly equivalent opportunity for each side to give their explanation of what occurred. The accused party is entitled to no allegations, but it's a good process to reveal the allegations during the interview rather than before, because you don't want someone preparing for or making up a story. You want to make sure that it comes out naturally in response to the questions that are asked. It may not be necessary to disclose the identity of the complaining party, but that's a case-by-case determination. Step 3, relevant witnesses should be interviewed and relevant documents should be reviewed. So, in the course of talking to an accuser or the accused, certain names may pop up, people who were in the room, people who said or heard things. And it's important to talk to those people, follow those leads. And if there are letters, emails, text messages, these are things that should be reviewed, assuming they are available to confirm or undermine the allegations. Next slide. Step 4, whatever else is necessary to get the facts. Perhaps it's appropriate to visit a location where an incident supposedly occurred. You want to see perhaps an office or a workshop or a bar or wherever the incidents occurred. If there are videotapes or pictures, it may be important to see those as well. Develop a complete context where there are not holes. Step 5, gather any relevant documents that you've seen or wanted to see, so that you have a complete record. And then step 6, reach a reasonable and fair conclusion based upon the information collected, reviewed, and analyzed during that investigation. And you should be able to explain the outcome of your investigation based upon the facts and the analysis. And that's typically in a report, which we'll talk about as we go on. Next slide. Can the investigator keep the complaint confidential? No. Employers can only promise limited confidentiality, that the information will be limited to those who need to know. An investigator cannot promise complete confidentiality because it may be necessary to disclose information obtained during the investigation to complete the investigation and take appropriate action. And can the investigator tell employees, or can an employer generally tell the employees not to talk about the investigation? I mentioned this briefly a bit ago. It's a complicated issue, and managers can and should be told to keep that complaint confidential and the investigation confidential. But there have been court rulings, legal rulings on what to do with employees. So it's important to look at the details before making a decision. Next slide. Impartiality is really vital to the success of a sexual harassment investigation. The findings in a harassment investigation should be based on objective assessment of evidence. It is important to look at whether the investigator has any biases that could interfere with the fair and impartial finding. And if that investigator cannot be neutral, that investigator should recuse him or herself so that someone else can step in to conduct the investigation. And even if an investigator determines that he or she can be neutral or impartial, there can be an issue of perceived bias. The investigator needs to consider whether that person's involvement might provide a perception that the investigator has some link to the employer or a party to the investigation. So if there is perceived bias, that could impact, discourage dialogue with all the parties involved in the investigation. Let's talk about some of the basics in investigation activity, and one of them has to do with burden of proof. In other words, how much evidence is needed to make the case. The investigator should make findings based upon a preponderance of the evidence. Preponderance, we typically talk about more probable than not that something occurred. It's important not to reach legal conclusions. It's important to look at factual conclusions, perhaps credibility assessments, but not conclusions under the law. Documentation is important. Investigators need to look at witness interviews, findings, steps made, and various papers that can help make the case, evidence one way or the other on the allegations. Next slide, questioning is important. The manner in which questioning is conducted can very well impact how a witness responds and the quality of information that someone gets. Investigations should not be interrogations. They should not be aggressive. No one should feel that they are being cross-examined. Instead, questions should be open-ended on relevant topics so that there is complete information from the parties and the witnesses. There are some credibility factors that should be considered in assessing the allegation of harassment or the defense to it. One is inherent plausibility. Are the facts put forward by the witness reasonable facts? Are they something that is likely to occur or unlikely? Number two, is there a motive to lie? Is there any reason why someone would not be truthful? Three is corroboration. Are there other witnesses? Are there documents or events or something that would align with the facts stated by a given witness? Four, to what extent was a witness able to perceive, remember, or communicate about a matter? Is there any gap in recollection? Or perhaps the seemed understanding or awareness of a particular issue. Number five, is there any history of honesty or dishonesty with a particular witness? Does that impact how likely you are to believe that individual the next time around? Number six, habit and consistency. They can sometimes be probative. If there is some sort of behavior that someone does on a regular basis, such as being aware that a particular employee hugs employees regularly. That sort of behavior could be a component of a harassment allegation, and it may be something people are aware of because they know that person, having worked with them for a period of time. Number seven, inconsistent statements. To what extent are the things said by a particular witness consistent? Has the story changed from one time to another? Number eight, the manner of testimony. Is there something about the way the individual speaks on a topic that suggests that they are hesitating, that they are scared, that they are being evasive? And the quality of a response based upon the subject matter at that moment, that can impact how someone's credibility is perceived. And nine, demeanor. And this is something that is a hard one to assess unless you are truly an expert in assessing demeanor. It would probably be best to rely on factors 1 through 8 more than number 9, unless you are truly experienced and have expertise in the investigation field. Next slide, some other issues. It often comes up that an employee will say, this happened to me, I think it's sexual harassment, but I don't want you to do anything about it, I just want to tell you. And it's important that every employer, every investigator know that an employer is not allowed to sit there and do nothing, to not report an issue that has been brought to his or her attention. It's if there's something minor, perhaps it's appropriate to ask for advice, or a supervisor or manager should ask for advice on how best to handle that. But as a general matter, if there is an issue which is considered to be harassment or in reasonable judgment is likely to rise to a level of harassment or abusive conduct, it's something that the supervisor or manager should act upon pursuant to the policy, report it to the appropriate person, and take steps to initiate investigation or to stop active misconduct. It's important that the employer be made aware, because supervisors and managers are the eyes and ears. They are the actors for the employer, and once they know of potential wrongdoing, the company is on notice. So it's not appropriate to allow that activity to go on unchecked. Instead, it is important to intervene with the investigation and any other appropriate action. Let's talk about some other issues, such as anonymous complaints. Um, let's say a complaint comes in, you don't know who it comes from. The employer should be made aware of the need to investigate anonymous complaints the same way as they would with a complaint from a known accuser. And to the best of the ability of that employer to gather facts, the employer should do so. If there is a lack of cooperation or inability to fill gaps in the investigation, that should be noted. But it is important that the employer be aware of the need to make best efforts to investigate that complaint the way they would any other. If there are administrative complaints or suits related to harassment, even external complaints need to be investigated, and it's possible that counsel is involved. It's important to make sure not to bypass counsel. The investigator should act appropriately in that way. With retaliation, it's important to be mindful that um, everyone who participates in the investigation should be protected against retaliation. And uh, employers should tell complainants, witnesses, everyone that retaliation is illegal, and should counsel everyone not to retaliate and to be alert to signs of retaliation, to report them if retaliation is found. It's also important to uh, take reasonable steps to prevent and correct unlawful behavior. To meet this obligation, an employer should stop behavior before it rises to the level of unlawful conduct. And that's where some of the bystander training I mentioned earlier comes into play. If you see something and it affects somebody else, employees, supervisors, managers should be aware of ways they can intervene to make it stop. It is important for an employer to impose remedial action, which is commensurate with the level of misconduct and discourages recurrence. And consistency is important. If you have good policies and practices, you should do your best to make sure there is consistency so that it's you're better able to avoid claims of unfair, inconsistent, or discriminatory remedial measures. Now, I want to cover as we approach the end of this presentation some thoughts that employees might raise if they are looking at issues of harassment, discrimination, and potential retaliation, particularly if they are looking at litigating these issues because they are not satisfied with the way in which an employer has handled them. From the plaintiff's perspective, they say sexual harassment stops here, and plaintiffs are looking at the issue of failure to prevent discrimination and harassment under California law or any other applicable law. California law gives plaintiffs the ability to seek discovery of employer policies and training, and to look for Me Too evidence to show that one individual plaintiff is not the only one dealing with a particular set of circumstances. It's possible to collect attorney's fees, and it's important to talk to an HR expert to make sure you get all the information needed to make the best possible case. Let's look at some of the issues that could come up with investigations that give rise to discrimination or retaliation claims. There's case authority cited here to the effect that an employer needs to conduct fair, prompt, and unbiased investigations for the reasons we talked about earlier. And employers need to show that they have a good faith belief of wrongdoing after conducting a fair, reasonable, and good faith investigation. And a deficient investigation can actually provide evidence of discrimination or retaliatory animus. So let's say an employer did not follow leads, did not talk to witnesses, did not consider documents or other evidence that was made available or offered, and reaches a conclusion that is off base. That can show a defective investigation with separate legal repercussions, enhancing a claim of harassment or discrimination. There are issues of sham and inadequate investigations, and that issue has been heavily litigated. It is very typical in litigation that an investigation is attacked with an employee plaintiff looking at the written policies. Are they current or are they outdated? Have they been modified to address changes in the applicable law? It's important that in those instances, an employee plaintiff look at how written policies were or were not put into effect. The implementation is going to come into evidence because the employer is going to want to make the case that they aspire to follow the law. Their policies were drafted probably by lawyers, and they had all the appropriate training, and so the plaintiff will be looking for holes in that. The plaintiff will be looking at an investigation report to see how was this investigation conducted? Was it thorough? Was it unbiased? And were there any holes? The plaintiff is very likely going to want to talk to the investigator and in a deposition discuss the training and experience of the investigator and whether there is any bias in how the investigator conducted that investigation. If there were any third-party witnesses, there will likely be depositions of them as well. And to the extent possible, confidentiality, as we've noted, is a part of the investigation process, and it will be important to explore whether confidentiality was maintained. The plaintiff will want to explore whether a complainant and witnesses were interviewed, how, by whom, and in what manner. The more casual, the more delayed, the more offhanded, the more likely a case can be made that the accusations were not taken seriously. And we often see that when harassment issues arise, there are allegations made against the accuser. The accuser told bad jokes too. The accuser groped people too. There are a number of issues that tend to reflect back on the person who originates the harassment complaint. And it's important that everyone involved look at whether the investigation turns into an effort to retaliate against a plaintiff. It is important that an employer be aware that the evidence will be looked at for that sort of issue, and whether there was any exculpatory evidence that was overlooked in the course of the investigation. So plaintiffs are going to look at whether the investigator was experienced or biased, and that the investigator was looking into the issues of harassment rather than drilling down into misconduct or poor performance by the accuser. Again, who was interviewed, the manner in which the interviews were conducted. Was it an interrogation, a cross-examination, or was it truly calm, reasoned, open questions designed to gather facts from witnesses' recollection? The order of questions, the scope of questions, and whether the facts gleaned from the investigation are consistent with the conclusion that was reached. And in terms of the investigation report and conclusions, is there a history of the same conclusion being reached over and over? And was it simply a rote sort of exercise, or was it truly an analysis of the facts? Next slide, in terms of interviewing a complainant, if the complainant is no longer employed, there are questions to be considered. Should the complainant still be interviewed? Should the lawyer be allowed to attend? These are questions that will differ with every case. And if a complaint is filed with the Department of Fair Employment and Housing or the EEOC, it's very possible that the complainant's attorney is involved in filing and in helping to present evidence. And these are all things that need to be carefully considered. A plaintiff is going to want to look at the investigation report, what the investigator gathered, the documents and other evidence, and what scope of documents was reviewed, what witnesses were asked about, and whether there are credibility and fact assessments. And is there anything unrelated involving personal opinions, legal conclusions, and so forth? Lots of different factors to be considered. And in terms of the conclusion to investigation, did the harasser's conduct violate the company's policy as stated? What is the severity of the violation, considering the potential outcomes that there could be? What past practice is there, and how does the action taken compare to past practice? Is it consistent or inconsistent? And who made the decision if there was adverse action? Was it taken seriously? Was it elevated to an unusual level? Was it delayed? There are all sorts of questions in terms of practice and execution on the decision. And it is now possible for plaintiffs to get employer responses when there are accusations filed with the government involving harassment. So it's possible to discover and review what the employer stated in position papers, whether there is any inconsistency or gap, and whether that raises any red flags in terms of the investigation. So that's a lot about training and a lot about investigations. And with that, I am going to wrap this program, but I encourage you to dig more into this and to take steps to learn more about the training, the policies, and the investigation required to deal effectively with harassment, abusive conduct, and discrimination in the workplace, whether you are in California or elsewhere, and to follow developments, because these issues will continue to develop in this environment where there is constant legislation, regulation, and litigation. And with that, I thank you. Have a good day.